We are on record this morning following a request for preliminary hearing and removal of this child. I've had the pleasure of chatting with the attorneys before we got onto the record today, so I'll let them address that as well after appearances.
Lee Heiss, lawyer guardian ad litem.
Nastasia Thomas, counsel for the department.
Chelsea Grant with the department.
Samaris Hennigan, counsel for minor child's mother, Cassandra Roche.
I'm Cassandra Roche. I am Odessa May's mother.
Thank you.
Michael McFarland, representing the minor child. I'm not going to say your name because we're on YouTube, but if you just stand up and say hi to the judge.
Hi.
All right, comments for the record about the sidebar, Ms. Thomas.
Thank you, Your Honor. In this case, there is a legal custodian, the maternal grandfather, and he was listed on the petition. During our sidebar, we believe that there's a legal pathway to change the custody order and dismiss him from our petition, and allowing us to move forward with a request for removal in place with the department in a qualified residential treatment program. And that would continue to be our request today.
All right. Could you also address for the record the issue of the first amended second petition that was filed?
Yes. Your Honor, after our scheduled preliminary hearing yesterday, I was under the impression that we needed an ex parte order for removal, as residential treatment facilities are very hard to, come by in openings. And I was under the impression that we needed to get an order if we were able to maintain and secure that bed for her. And so I immediately filed an ex parte petition asking for that relief. And I would formally ask the court to dismiss the ex parte petition and simply go from the original petition filed on this case.
Thank you. Your position, Mr. McFarland? And comments about our second?
I would agree with the comments. I know that I think that I also discussed that we have to use the frame of what's in the best interest of the child, minor child, and the release of custody. And I anticipate I will challenge that.
Your position and any comments on the sidebar?
Your Honor, representing biological mom who has indicated that she is willing to take custody of the child and to enter into case services with the agency. She feels that while that's a very difficult decision to make with regard to entering into services, that from her perspective, this is what's best for the minor child, and mom would embrace the opportunity to get services herself and for the minor child to have services, with the hope that one day they will be able to reach a point of reunification, but very realistic about the need for services for this family in order for them to reach that goal.
I believe we've had a correct recitation of the sidebar, and I was able to participate, and we all came up with good solutions, I feel. And so I agree with the solution proposed by the state.
Thank you. All right. So the court will, essentially what I'm going to do is I'm just going to not authorize that amended petition. So I won't move on that, but I will move on the original petition that was filed, I believe, on October 1st. Is that right, Ms. Thomas?
I think on Monday the 2nd, it was filed.
The 2nd. Thank you so much. All right. So we'll move on that one. I have received also some additional documents. So maybe we should go ahead and review what we've received with regard to this petition to make sure that I have everything that I'm supposed to have, and then everyone else also has those documents I have, in addition to the initial petition that was filed, a 5598 to the Blackfeet tribe for Odessa and Johnson. So there is some indication here then of Native American heritage. There's another 5598, which is the inquiry form sent to the Cherokee Nation. Attached to that is a certified mail receipt, but it does indicate that these inquiries were sent to more than just these two tribes. It looks like it was sent to Blackfeet Tribe of Montana, United Kiowa Band of Cherokees, Cherokee Nation, and the Eastern Band of Cherokee Indians. So, I think we would need copies of the two things that I don't have, which in this case would be one sent to North Carolina, and one of the ones sent to Oklahoma.
Your Honor, if I may, the Cherokee, the DHS form, with the one that says Cherokee Nation, that same packet is sent to the 3 Cherokee Nations that are on the certified receipts, or to the tribes. I'm not sure on the proper language there, but they're all affiliated with the Cherokee Nation, and so they are sent to those 3.
Well, I appreciate that information. I guess I'm having a little trouble or confusion about why the 5598s are specifically addressed to Cherokee Nation in Oklahoma and Blackfeet Tribe in Montana. And then I have certified mail receipts that indicating that 2 other locations were also served. But are you telling me that the same, even though they have a different address, that they were sent to these other addresses? I guess I'm confused.
That is my understanding, and I guess I should allow the department to testify at that point.
I also found an inquiry sent to the Midwest Regional Director in Bloomington, Minnesota, and that's not reflected in the certified mail receipts that I have. So perhaps we need some clarification on that point. But that's what I have attached to the petition initially. Is that everything that should have been attached to the initial petition, if you can verify that?
It is, Judge. And then yesterday, you received more documents, and we would ask the court to consider those as part of the filing today.
All right, so I'm going to run through those. First, I received a custody order dated May 7th, 2015, which concerns 4 different cases. 14-40959DP, 14-40960DC, 13-48208GM, 13-48209GM. Another order I received is dated March 9th, 2018, and is simply for case number 14-40960DC. There is an order in file number 13-48208GM, which simply closes that file because of the verification of the custody order and the other files that I previously referenced. There's a form 6051, Child Welfare Placement Assistance Request, and a notice, Maximus Notice of QRTP Qualified Individual Assessment Outcome, explanation, and the assessment summary. And finally, I believe this is the Wedgwood Christian Services admissions packet. I think that's all I have. Is that what I'm supposed to have?
Yes, Your Honor. Thank you.
A courtroom hearing takes a shocking turn when the state asks a judge to remove a child from their home and place them in a treatment facility. The child already has a legal custodian, the grandfather, but officials claim removal may still be necessary. In a surprise moment, the mother says she's willing to cooperate with services to help her child and eventually reunite. But just as the case moves forward, the judge discovers the child may have Native American heritage, meaning tribes like the Cherokee Nation must legally be notified, forcing the court to pause before making any decision about the child's future.
All right, let's go to the attorneys. Mr. McFarland, do you have copies of this?
I do, Your Honor. I have no objection.
Okay, Ms. Hannigan?
No objection, Your Honor.
Right. Ms. Heiss?
I have received and reviewed them. I have no objection to the court accepting those as exhibits with the petition.
Thank you. All right, very good. Okay, so Mr. You're usually who I address for purposes of fairness, so my apologies. Ms. Hennigan, have you inquired of your client whether or not she's received a copy of the petition?
Yes, I have.
All right, Deputy Ames, let's invite you up, if you could, to have a seat next to your attorney. And Deputy Ames, can you swear her in, please? Ms. Cassandra, is it Rush?
Yes, ma'am.
Rush.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, so you have received a copy of the petition?
Yes, ma'am.
All right, and
I received paper and email, so I got it in both copies.
very good. Okay. Are you, do you have any reason to believe that you are a member of or would be eligible for membership in any Native American tribe?
My mom's got Native in her, as long as Polak and Irish.
All right. And do you?
I'm under the assumption I have Indian heritage through my mother.
Okay.
That's what
do you know what tribes would be?
Cherokee and Blackfoot.
All right. That's good. That's who it looks like there's out on. Great. You obviously have the right to an attorney. You have an attorney from the Public Defender's Office. You'll have her here for each and every hearing, unless you find your own attorney and you'd rather have that person here instead of Ms. Hennigan. You have the right to have the petition read out loud onto the record, as well as the right to admit or deny the allegations in each paragraph. Ms. Hennigan, have you talked with her about whether or not she wants to waive the reading of the petition?
We can waive the reading.
All right, that's fine. And then, Ms. Rausch, your attorney has indicated that you would like to take responsibility for the allegations in the petition. In other words, enter a plea. Is that right?
Yes, ma'am.
Very good. I went through some of the things that were filed along with the initial petition that reference other cases that concern your child. Were you able to hear that?
Yes, ma'am.
Okay. Other than those cases, are you aware, and I'll say this, I know also that there's a delinquency case for your daughter.
Yes.
So other than those cases, are you aware of any other court that has any orders out or cases that would be out there about your child?
No, ma'am. She's only resided in West Virginia or Michigan since she was 11 months old. That's the only state she's ever been in besides West Virginia.
I know there's also a request for a DNA testing for Mr. Brad Rublatus. He is the potential putative father of your daughter. Is that right?
Yes, ma'am.
Thank you for clarifying. Okay. Would you like me to head into the plea stage of this at this point? Ms. Thomas, do you have a preference on that?
I do not, Your Honor.
Your Honor, I don't think that she's the custodial parent, so that adjudicating this mother at this time still doesn't accomplish what we need for the child because the custody resides in the grandfather.
That's fair. So we can handle the custody issue first. All right. Let me go back to that documentation. Okay. Ms. Rausch, is it true that, as you understand it, Mr. Gregory Rausch has custody of your daughter at this time?
Yes, ma'am.
we have Mr. Roush here?
Yes, Your Honor.
Okay, welcome. Would you mind stepping up to the podium for me? Deputy Ames, would you please swear in?
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. All right, Mr. Gregory Resch, I have in front of me a court order issued May 7th, 2015 that appears to give you joint legal custody and primary physical custody of the minor child, in this case, OJ. Is that right?
Yes.
Okay. Now, I understand that there may be some potential problems in the home with you and this child based on what I read in the petition. Were you able to get a copy of the petition that concerns you as well?
I believe so. I got paperwork back on the bench.
Okay, all right. Do you want to try to salvage your relationship with this child, or how do you see your involvement with this moving forward?
I want to stay involved, yes, but due to the behavior and things at home, I'm trying to get her help to resolve those issues, and with CMH and CPS involved and going through Wedgwood services, hopefully those things will change and then she will get better and then she possibly come back or stay with her mother.
Okay. So you're indicated as a respondent in this case, but you're not a parent, you're a custodial
Correct.
parent, right? So I can afford you the right to admit or deny the allegations in the petition. If you want to be part of the proceedings moving forward, then you would have to decide whether or not you want to admit or deny the allegations and submit to the supervision and jurisdiction of the court. You could have a trial on those allegations as a custodial person for this child, or if you don't wish to have legal custody of this child anymore, we can open up that case and look at that as well.
No, what I was wanting to do is try to keep the legal custody, but then be involved in future care or whatever that, that she needs to help her get better.
So, typically only an actual parent would be afforded an attorney in these proceedings, but if you wish to assert your custodial rights, I think I'd like to take a break and find you an attorney moving forward, because these proceedings can be complicated. So you've got a right to a trial by judge or jury on each of the allegations in the petition that concern you. You have a right to admit or deny those allegations in that petition, but you're not an attorney, and I wouldn't expect you to be one. And I'd like to appoint an attorney to help you make those decisions.
Okay.
Okay? So why don't you have a seat, and we'll see if we can't find somebody for you. And then in the meantime, I'll just make a decision today on what's going to be happening with your granddaughter in the meantime, okay?
Okay, thank you, Your
Okay, well, that changes things a little bit from our conversation in chambers, which is fine. So for purposes of today, I have to decide whether or not to authorize this petition, and first and foremost, whether or not to take jurisdiction over the minor child. I am certainly also willing to allow Ms. Cassandra Roush to enter a plea if she'd like to engage in services and move that direction as well. And then we can table things as it appears for Mr. Gregory Roush, as well as, of course, the father, who's DNA holding his pending, as I understand. Your thoughts about that, Ms. Thomas?
Yes, Your Honor, I am agreeable to that. And if we need Ms. Grant to testify in order to, I guess in my brain, I'm thinking removal, hearing, prelim, plea. So,
In a tense court moment, the mother confirms she received the petition and admits she may have Native American heritage through the Cherokee Nation and the Blackfeet tribe. Then the judge calls the child's grandfather, the person with legal custody, who says he still wants to stay involved, but admits the child's behavior has become difficult and she may need help. Realizing how serious the case is, the judge pauses the hearing and offers to appoint the grandfather his own lawyer before deciding the child's future.
Ms. Grant needs to be sworn in. I'm happy to do some questioning right now.
Any objections to that?
No.
No, Your Honor.
No. Right, come on to our witness stand.
Just to advise the court, I have reached out to the public defender's office for a attorney.
Thank you.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Ms. Grant.
Morning.
Can you please tell us how you are involved in this matter?
I am the Children's Services ongoing worker for the family.
And did you draft the petition that is filed before the court today?
I did.
And I'm just going to kind of go down the petition, I guess, sort of how we look at it. And the first thing would be the ICWA documentation. Do you have any information on that and what DHS forms were sent to the tribes that correspond with the receipt?
Sure. So I did look over the ICWA information. It is sent to the three Cherokee tribes and the Blackfeet tribe. The way the form should be filled out is it should just say Cherokee, not Cherokee Nation or the address. So that is incorrect. However, they just do one form and send one form to all three Cherokees, so that is correct. It's just the form was incorrect from the investigator who had completed that. I can resend all that if that would appease the court so that it is correct with the correct information.
And do you have any information on I guess typically when it's sent to the BIA, then they send back stating who to send it to. Did we get a notice or anything from them, or was that actually sent today?
I would have to inquire with our clerk that sends the documentation out for us. We don't personally send that out or keep track of the green cards when they are returned until after they're returned and given to us. She keeps track of all of that in a spreadsheet for us.
Thank you. Okay. And as the ongoing worker, how long have you been working with this family?
I received this case in late June, beginning of July. However, the family has had CPS involvement pretty frequently since December of 2022.
And generally, what has CPS been involved, or what is the reason CPS has been involved?
On and off again, a lot of the reasons why CPS has been involved is because of OJ's increasing behavior in the home. OJ has become more aggressive. It has caused her to receive frequent referrals regarding criminal activity. She has several pending domestic violence against the caregiver, Mr. Roche. She has, originally she was in services when the case originally opened during one of the preliminary investigations back in December. The family was referred to prevention. She was in ACPC and seeing Dr. Sandu at the time. However, they both felt that those services were not intense enough for her. And prevention through us did help get them transferred into CMH, where they started home-based therapy. They've been involved in wraparound. The school has provided ongoing services for her at school as well. However, they appear not to be sufficient enough to meet her needs and ongoing behavior issues. We became involved for this open case that we have right now. Ms. Roche was exercising a parenting time with OJ in which OJ had one of her explosive behavior episodes. Ms. Roche did try to physically restrain her at that time. However, they continued to engage in physical altercation where OJ had actually bit Ms. Roche. And in return, Ms. Roche did also bite OJ back. At that time, we opened a case for services. In the attempts to get Ms. Roche established, she had just recently moved back full-time from West Virginia and did not have and continues not to have a place to live. I had asked her to get a driver's license, but because she didn't have a place to live, she wasn't able to do that. However, she was able to get benefits through the state that just within the last month were able to clear and start going for her to even begin services of her own.
And part of the petition also requests removal from the legal custodian. And can you please, go into why continued custody and his care poses a risk of harm to the child?
Sure. So ever since I have been involved in June, OJ has had several instances where she's had the police called and had to report to campus for those reasons. Being that Mr. Roche has stated that he's not capable of caring for her or meeting her needs in those instances. The first instance was after, I believe, a wraparound meeting. OJ was extremely upset that she's not able to go and live with mom at this time because mom isn't able to fully meet her needs while she's still trying to sort out meeting her own needs. And during that time, OJ is cognitively impaired and diagnosed with that through school with her IEP. So she has a difficult time understanding mom's needs and the things mom needs to do to be able to meet her needs. So in doing that, there was a verbal argument between her and Mr. Roche in which she began throwing all of her stuff out of the home. When Mr. Roche tried to tell her that she couldn't just leave the home and she couldn't run away, I believe she sprayed perfume in his eyes and he had to call police. She was held in campus for 24 hours. He had agreed at that point to go and pick up OJ, however, expressed concern that if her behaviors aren't getting better, that he's not going to be able to take care of her for much longer. He talks about his health issues and her increasing physical behaviors that he just is unable to monitor and control. The following week, there was another incident in which OJ physically assaulted him, leaving him with a black eye, where she, again, was picked up and taken to campus for a 24-hour hold. However, he had stated that he did not plan on picking her up, nor did he want to. He stated he could no longer care for her, so we went through trying to find family members that would be willing to care for Odessa, school. Immediately, we were able to find a maternal grandmother who was able to care for Odessa. During that week, she had called several times regarding OJ's ongoing behavior, including cursing, screaming, throwing things, breaking things, refusing to shower, refusing basic hygiene, refusing to take medications. We had 2 emergency meetings, one being a wraparound, one being a family team meeting, trying to establish, some kind of stability for her staying with grandma. However, over the weekend, I received calls that Monday morning that OJ had started a fire in the home that to get into a safe. She had lit a lampshade on fire, melted a lock on a safe, causing scorches, I believe, to the ground and the walls. She was picked up and brought in for an emergency delinquency hearing where she was held in the campus for 24 hours until I believe a probation violation was held. Where she was in campus, I believe, for 30 days. And from there, Mr. Roche did not wish to forever care for her and stated that she would need somewhere much more substantial for her behaviors. There were no friends and family that were available that were willing to care for her at this time. There was no school official, so as the department, we started the inquiry to foster care homes. After we got several denials for foster care homes, it gave us the opportunity to then look at temporary shelters who also denied her stay. From there, a RP, which is a residential placement unit referral, was completed, and then also a intensive placement unit referral was completed, and that search for residential began.
And currently, it sounds like, there were a lot of efforts to prevent the removal, and then two, also to an attempt to maintain this youth in the community or the least restrictive environment to ensure her safety. When today part of the petition is also the the Maximus assessment. What does that assessment say about whether the youth qualifies for residential treatment?
Through the assessment, she talked to several individuals, including myself, I believe the probation officer, parents, and it does state that OJ qualifies for residential placement.
And placement has been secured at Wedgwood.
That is correct. Her original admissions date was for yesterday. However, due to the fact that their admissions closed around 4 or 5, and by the time, even if an ex parte had been filed, we wouldn't have been able to make it there. We did call and make arrangements for the admissions date to be today.
Thank you. Do you know what parenting time would look like with mom and grandpa there?
So it would be supervised, but I don't know how frequent that would be. This is my first time personally working with a residential, but I know that the whole point would be therapeutic visits and to really build that relationship.
Thank you. Your Honor, I have no further questions of Ms. Grant.
Okay. Rollins?
I'm gonna come up here, we can hear me, not in the corner. The maternal grandmother where the child was placed for a while, is this the individual that might have Native American heritage?
My understanding is yes.
Have you spoken to her since she's one who might have heritage to see what heritage she might have?
I can. I have not personally. This was filled out by the investigator, but I have no problem doing that.
Okay. The current custodian, you spoke to him to see if he has Native American heritage?
Yes.
And his response?
He denied.
Okay. And my understanding that there is a potential father who's going to have DNA testing done, correct?
This is correct.
When was he identified and when was this testing asked for?
So he's actually identified way back when the first proceedings with Children's Services took place back in 2014. He was actually on that petition as well. However, he never complied, never came to court, never completed any DNA, anything like that. During the current investigation, he was reached out again regarding punitive, and I believe that was in June. The referral and the DNA testing was completed in July, and our program manager has checked pretty much every day to see if the DNA testing has come in yet, to confirm or deny if he is father. But
so he has taken it?
Yes, both him and the child have taken it.
Has he shown any interest in housing the child?
Yes, he's just, he lives in Ohio.
Where in Ohio? Just over the border?
He lives in Tiffin, Ohio.
Okay, well, just a little ways. Wedgwood's at Grand Rapids, Michigan, approximately?
That's correct.
Would you be providing transportation for a mother to go up 3 times a week as she'd normally visit down here if the child were local?
That would be something the foster care worker would have to possibly be able to facilitate for her. I know gift cards and things are definitely feasible.
Wedgwood, does that involve children with other issues like my client?
Correct.
Have you explored placement here in Adrian? My understanding that there is a juvenile placement facility here in Adrian. Have you explored that?
My understanding is due to her developmental delays, there's a lot of facilities that will not take her because of that. There were 3.
I'm asking, have you asked them?
I personally have not.
And we don't know that they wouldn't take her if we haven't asked, right?
That would be maybe the IPU or RPU unit that handles that through the state, but I can definitely inquire about it.
Okay, nothing further.
Good morning, Ms. Grant. Have you had an opportunity to speak with my client, Cassandra?
I have.
And through your conversations with her, Is it your impression that she intends to cooperate with case services?
Yes.
If given the opportunity to be the decision maker for the child at this time, do you believe that she will work with the agency to get the child into appropriate placement?
Yes.
And do you believe at this time that it's in the best interest of the child for her own safety and the safety of others that she go into placement?
Yes.
Is it your position at this time that the current custodian is not capable or not willing to take care of the child?
Yes.
Thank you. No other questions this time.
Are you saying that since this family came into CPS attention maybe in 2014, that there has been improvements in mother's ability to parent this child?
The same concerns are still present from the same concerns of when the guardianship originally went in are there, being that she doesn't have a home, she's not engaged in services. I do think she does put the best interests of her child in play, which is like allowing the guardianship, allowing her to reside with Mr. Roche. I think the issue that we run into a lot with Ms. Roche is that she makes a lot of promises sometimes to OJ that she cannot keep. Like, I'm going to do, you're going to come home to me right away, where there's no understanding of the timeline of how long that could take.
Okay, so you're not necessarily saying mother is appropriate for placement, right?
Correct.
But she's appropriate for services towards reunification.
Correct.
In one of the custody documents, there's a person named Clarence Shermhorn or something. Who is that person?
So Clarence is Cassandra's former partner. They actually share a child together.
Not this child.
Not this child. Right. But Odessa does look at Clarence as her father.
Okay.
She does not have a strong relationship with the putative father.
Okay. Is the putative biological father participating, agreeing to do the DNA?
Yes, he's already completed it. It's still pending.
That's right. You said. And then also there's in your materials, there's an exhaustive list of placements that have been researched for this child. Is that correct?
Yes.
So you've looked through, I don't know, have you counted how many there are here?
I have not. Our licensing department handles that in contacting the licensing homes.
So there's probably 50 at least, if not more, contacts made for foster care placement of this child, correct?
Correct.
So we got no yes, we didn't get anybody willing to accept this child throughout the state of Michigan, is that correct?
Until we went into looking at RPU and IPU, yeah.
Okay, so then when we start the RPU and IPU, those would be, let's see, just a minute here. Okay, so we even list a lot of those places that were unwilling to accept her as a placement, correct?
That is correct.
All right, so this place that you found is in Grand Rapids, Michigan?
This is correct.
The place that you're proposing that has agreed to accept her, is that residential or intensive?
I believe it is only residential. However, it's able to meet both her cognitive issues as well as her mental health and behavior issues.
Thank you. Nothing further.
Any retract?
No, Your Honor.
Recross?
Briefly. You had mentioned a father figure in my client's life, Clarence. My client would like to have him explored. Do you know if he was explored as a fictive kin for placement?
I think he also is homeless and is not having a stable placement. Able to care for her needs.
So you think, you know that? How did you come about that information?
From speaking with Cassie and Mr. Roche.
Okay. You have a phone number for him? Did you approach him that way?
I did not. I know that I believe his mother was also asked, and she's not able to meet the needs for the child either.
Nothing further.
Any other requests?
No, Your Honor.
Thank you for your testimony. May I return to your seat?
A shocking moment hits the courtroom when a child services worker reveals the child's behavior has spiraled out of control. Multiple police calls, violent attacks on her grandfather, and even setting a fire inside the house to break into a safe. Officials say they tried therapy, school support, and even contacted dozens of foster homes, but no one would take her. Now the state says the only option left is sending her to a residential treatment facility for serious help.
Anyone else would like us to hear from Ms. Thomas?
No, Your Honor.
Okay,
Your Honor, I do have an update on the attorney issue.
go ahead.
Public Defender's Office does not have one available. Ms. Berger will be available when she returns from her honeymoon. I'm not sure.
You might want to speak up.
Thank you. Your Honor, Public Defender's Office contacted me. There's not an attorney that's available to represent the legal custodian. There is one who is on a short leave. Ms. Berger, as the court knows, she's the only one that we can reach out to.
Okay, all right. So we'll set some hearings up for Mr. Roush for when she's returned from her vacation, and we'll go from there. Anyone else you'd like me to hear from on the issue of authorization of the petition in securing jurisdiction over your client and, frankly, the request for placement in a qualified residential treatment program?
My client would like to testify as to where she would like to be, Your Honor.
All right, Deputy Ames, Ms. Odessa Johnson.
I'm just going to call you OJ up there, okay? Oh, just get your shoes on, Your Honor.
Let's leave those on.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, so down here, be careful of that step right there. Right up to the microphone.
I'm going to call you OJ, okay? And I need to have you speak up really loud because we're recording this. Can you say yes, Mr. McFarland? No, much louder.
Yes.
Louder?
Yes.
Good, that's good. What do you understand that we are doing here today? Well, do you remember I explained to you that both your mother and your grandfather believe that you need to go to a special facility to get better, so your behavior and your mental health is under control? Do you understand that? And that's a couple hours away from here. If you remember me telling you that? Yeah, speak up a little bit louder.
Yes.
Thank you. Where do you want to live right now, OJ? With your mother? If she doesn't have a home, is there any place else where you would like to live? Okay. What's your dad's name? Clarence? Okay, that's the person who you have a stepsister with?
Half-sister.
Half-sister, okay. So you would like him to be, you'd like the court to consider you placing with him. Is that what you're telling us?
Yeah, with the car.
What about this other person, Brad? Do you want to go with him? Is that a no?
No.
Okay. Is there anybody else who you might like to stay with?
Maybe.
Okay. Is this the grandma who they said that you may have started a fire? Is that the person?
Yes.
Okay, thank you. I have no other questions. I'll see if anybody else has any questions for you, okay?
Ms. Thomas?
I do not, Your Honor.
Ms. Hennigan?
No, Your Honor.
Ms. Heisen?
No questions. Thank you.
Okay, thank you for your testimony. May I return to your seat? careful on that step. Anyone else? Mr. McCarroll?
No, thank you.
Ms. Hennigan?
No, thank you, Your Honor.
Ms. Heiss?
Your Honor, I believe that there's a conflict in language, and I would like a few minutes to talk with the grandfather who's a custodial person, because I think that if I could voir dire him on the record, I don't know that we're going the right direction for him. But I would like a chance to either call him or maybe that's what I'll do. I'll just call him and voir dire him. Mr. Rush, would you come up to the witness stand?
Your Honor, I guess as the attorney for my client, I would object because the court has already said that he's entitled to an attorney, and here he's being brought up to the stand to be questioned without the opportunity to speak to an attorney.
I was going to ask him what his thoughts were on the request for residential placement in jurisdiction anyway, frankly. So, and he doesn't really have any constitutional rights in this case. We're in a gray area, but I appreciate your concern and making the record, but I'm going to rule that objection for now and ask Mr. Roush to come on up to our witness stand.
You're still sworn, sir.
Would you state your name for the record?
Gregory Resch.
Gregory Resch. Mr. Resch, you're the grandfather of who we're calling OJ here today,
Yes, that's correct.
and you've been raising her for quite a while.
Yes,
Now, we've come to a point in time where her behavior is something that needs more supervision than you can provide. Is that true? So in order to get that done, we're here today to say that we've got a place that can help her. You're aware of that?
yes,
So in order to get her there, we need the person with authority to accept the fact that things aren't going well so that we can get her to help. Do you understand that?
yes,
So what the agency told us is there's been a lot of bad behavior in your home. Is that true?
yes,
And the child has visited with mom, but mom hasn't been raising her, correct?
correct.
So you're the custodial parent. Do you understand?
Yes,
So when Judge asked you earlier whether you want to continue to be the custodial parent, you said yes, right?
yes,
And then you said you want to participate in this process of helping OJ do better, right?
correct.
Would you still continue to participate in the services if you weren't the custodial parent?
Yes,
So if mother were the custodial parent, you would still maybe visit the child if allowed?
yes,
And I understand so far you have been participating with wraparound services
yes,
and CMH,
yes,
and you've been trying to get her to go to school.
yes,
You've been making sure she goes to visits. So if you're the custodial parent, we'll get you an attorney so that you can look at the petition that alleges something was wrong in the home. You've seen that petition about what is wrong. So as the custodial parent, your attorney will help you decide whether you're responsible, which it's like a guilty plea, but that's not the right word, but that's what people understand. So that you would come towards accepting responsibility as a custodial parent.
Right.
Then you'd be involved in this case moving forward in services. Do you understand? If you're not the custodial parent and you walk away, the mom would be the custodial parent. We would look at the petition to see whether she is guilty. It's not quite that word isn't quite right, but whether she's responsible for fixing these behaviors. Do you understand?
yes.
Do you have a preference whether mother is the parent in this case or whether you are?
Well, currently, I'd prefer to stay where, and just have her go to somewhere where she's gonna get the care and
Good.
help that she needs.
So what we're gonna do is get you an attorney to go over that decision with you, and then we'll progress further in the case, okay?
Okay.
So you understand the good parts of your decision and the bad parts, okay?
Right.
Okay. Your Honor, I think you wanted to hear about something else. Thank you.
Yes, I think some of it we've already heard you talk about, but so one of the things I have to decide today is whether or not to authorize the petition, and whether or not there's probable cause that one or more of the allegations in the petition are true, and they rise to the level of requiring the court to intervene. And essentially, what's being asked is for me to take jurisdiction and supervision of your granddaughter, which means that I would basically be stepping into the role of deciding who she's going to be staying with. And they're asking for her to be basically for a foster care caseworker to be essentially put in charge of deciding where she's going to be, rather than you and rather than mom. And where the foster care caseworker and Ms. Thomas are asking is for us to send her to Wedgwood. So, do you have questions about that?
I was just assuming that I was gonna remain the legal, to have custody, but I finally found somewhere where I can send her to get help, and all I gotta do is sign the paperwork, and away she can go, not me abandoning everything, and then, letting somebody else, sign from here on. I assumed that I just said it, I was gonna still be a part of, the decision making.
I'm sure that Ms. Grant is going to continue to work with you and with the mom.
Not to sign away myself,
Right. Yeah, I know. I'm not asking you to do that today. I just have to make the decision. Because she can't go to Wedgwood unless I take jurisdiction and decide that it's not safe for her to be anywhere other than Wedgwood. So that's what I have to decide today. Everything else we're going to table. Okay? So, do you agree that she should go to Wedgwood or not?
Yes.
Okay. That's the main question I wanted to ask you.
Okay.
Ms. Thomas, any questions for Mr. Roush at this time?
No, Your Honor.
No, thank you.
Just a couple, Your Honor. Good morning, Mr. Roush.
Mine.
Parenting's fun, isn't it? So, can it be said that this has been a frustrating experience for you?
Correct.
And in your frustration, have you made any comments about not wanting to continue as the parent for the minor child right now?
Not wanting to care for her because of the abuse that I received at home, destruction of my property and, just physical problems that I am trying to deal with on my own for my back.
So, but just to clarify, today what you're telling the court is you still want to be involved in the decision making.
Right.
And if then those problems were resolved, then you may still be interested in physical care.
Not me, I will.
Thank you.
Oh.
No further questions. Okay, thank you so much for your testimony. We're going to have an attorney for you here in a couple of weeks, and we'll come back and let you talk with her first to decide how you want to proceed and everything else.
Okay. All right, thank you.
You're welcome. Be careful on that step, please.
In a tense courtroom moment, the young girl is asked where she wants to live, and she quietly says with her mother, or possibly her father. The judge then questions the grandfather who has been raising her, and he admits the situation at home has become overwhelming, but insists he still wants to stay involved in her life. After hearing everything, the court focuses on one crucial decision, whether the child should be sent to a residential treatment program so she can finally get the help she needs.
Okay, Ms. Heiss, anybody else you want to hear from?
No further witnesses, thank you.
All right, the issue of authorizing the petition, taking jurisdiction over the minor child, and the request for qualified residential treatment program. Comments, Ms. Thomas?
Thank you, Your Honor. I know that this court is also very aware of this youth's prior conduct and the situation surrounding that. And we would ask that the court find there would be a substantial risk of harm to the child's life, physical health, or mental well-being if she were to remain in the care of grandpa at this time, simply based on the inability to endure, I guess, the severity of those behaviors. And also given that the mother who does maintain legal rights is unable to provide that care right now as well. The department has, excuse me, the department and the community have provided extensive resources to this family in attempts to prevent the request for removal and to explore other potential arrangements. But at this time, no other arrangement is reasonably available to adequately safeguard the child from substantial risk of harm. There is a request for residential treatment given the pervasiveness of the behaviors, I suppose, the cognitive limitations that this youth also has. And given that the Maximus assessment does indicate she qualifies for residential treatment, we are asking the court to find that at this time, that is the most appropriate treatment, as her needs cannot be met in a foster care placement. One being that no foster care placements are available, and two, that the assessment itself has determined that her needs are greater than what foster care can provide her. In the residential treatment center, those conditions will be sufficient and adequate to safeguard the child. And it will also permit the child to participate in mental health services and behavioral health services in hopes to stabilize her and allow her to come home either to grandpa or mom. Thank you.
Okay. Any comments, Mr. McBrown?
I do. Your Honor, this does not sound like it's an instant case, but this has been rolling for a long time and building up a head of steam. The fictive kin appears, Clarence, has been known. We're just taking the word of mother that he's inadequate, not suitable, without even exploring him. This is a person with whom my client has a half-sister with. He should have been explored, hasn't been explored. He may take her, I don't know. But we've not fully, we've explored all these 50-some potential foster placements, but we haven't even explored a placement with a half-sibling, a fictive kin, somebody that my client knows and wants to be explored. If anybody asked my client that question, I'm sure she would have said the same thing she told this court. She doesn't want to go to Grand Rapids, which is several hours away. She'd like to be here locally, ideally with her mother, but if her mother's not capable, she would like to have this Clarence individual, who the agency knows about, to be explored for placement. Thank you, Your Honor.
Again?
Your Honor, biological mother is here today asking that the court consider the current custody arrangement that the court has already acknowledged today as joint legal with primary physical custody to grandfather, and that custody arrangement be changed to give biological mom temporary physical custody so that she may begin making the decisions for the minor child. As we've indicated, she is prepared to enter into a plea today and enter into a case service plan, which would include immediate placement for the child at Wedgwood. The ongoing caseworker here has testified that she does believe that the biological mother has a pattern of making the decisions that are in the best interest of her child, regardless of whether or not the child is actually placed with her. Mom is very excited to embrace the services and to work on her own situation, as well as get the help that the minor child needs with the hope of a future reunification. As to Mr. McFarland's interest in representing the minor child's desire to be with the individual who she knows as a father. My client has indicated that she is aware of his current situation and that he's recently had to move out of his brother's home. We've also heard that his mother, Clarence's mother, was contacted and is not willing to take the child. It is likely that he probably knows through his mother that these proceedings are ongoing as well. But very importantly, that the child's recent behavior has put herself and others at risk for safety with the fire setting and the assaults. And so even if the fictive kin is a possibility for future placement, we believe that it's in the child's best interest still to go to Wedgwood so that she can get some services prior to being placed back in a home-like setting. But we would ask today that the court would grant Ms. Cassandra Roche temporary physical custody of the child, and that she would then begin engaging in services with the agency on the child's behalf. Thank you.
Ms. Grant, before we get to Ms. Heiss, did you reach out to the putative father, Mr. Brad Rublatus, to explore him for placement?
Yes, he has no legal custody or anything right now, so until that is established, he would need to, that's why we started the DNA for placement. And then it would possibly be ICPC unless he was able to establish himself as legal father, which is what the DNA is pending for.
Do you have the authority to explore him for placement since he is implicated to be the father of the child, even without legal parentage?
My understanding is not over state lines. That's where the ICPC would come in unless he can be established as legal father.
Practically speaking, even if you didn't need the ICPC to do that investigation, would there be any way to determine whether or not he would be a safe person?
We did start the inquiries. He did live in West Virginia for a while. Those can take 60 days to come back. We're still waiting on those records to come back. We've requested Ohio records.
Can you move that microphone a little closer to you? Sorry, it's sounding really...
That's okay, this one right here. Okay.
I'll have to pull it down.
Can you hear me?
Better, yeah.
Okay. So he has lived in West Virginia and Ohio. We've requested those central registries to keep services. West Virginia takes up to 60 days to get those back, so we haven't gotten those yet. Criminal history and those have all started to be ran. He's never lived in the state of Michigan, so nothing comes back for him here. So we're really dependent on getting those records from Ohio and West Virginia.
All right. Do we know if he has any established relationship with the child at this time?
He has had a couple of visits over the last 6 months going with Gregory. They've gone to the mall and done things like that. He even sent me some pictures where OJ has visited his other daughter and things have seemed to go well. However, in speaking with OJ, she does not want a relationship at all with this man. She states it's because mom has told him that he's a very bad man. He's not someone she should be around. It's not her dad, that he has a criminal history, which he denies, which is why we're waiting on those West Virginia and Ohio State records to come back. So my understanding is while he has tried to build a relationship with her, OJ is very against trying to build any relationship with this man.
I see that you were able to email him. Do you know if he got notice?
Yes, he was on the hearing yesterday, although it was adjourned. I had known he is a truck driver, so he wasn't able, it could be he's driving and not able to appear today. But yes, I did send him everything.
Very good. And then the fictive kin that Mr. McFarland raised some questions about, was that explored by the department?
So I had asked Ms. Roche and Mr. Roche if they had any family friends or anybody that would be capable. Mr. I think Shimmerhorn Clarence was not brought up. He also does have a daughter that Gregory has also legal custody of, in which he is not currently caring for. So then that would explore opening to if he's even capable of caring for his own daughter, let alone OJ as well.
Questions based on my questions, counselors?
No, Your Honor.
Yes. So that's a no, you've not personally explored
I did not personally ask him, no.
Thank you.
No questions, Your Honor.
Ms. X?
No questions, thank you.
Thank you, Ms. Cooper. Your comments and recommendations?
Yes, Your Honor, I'd ask you to consider that the factual basis established today meets the level that we need to take jurisdiction. In this case, it's unusual, but we already have this Maximus evaluation, and the evaluation is saying the child's needs are such that residential would be appropriate, and the Maximus assessor has evaluated many people that know the child, are familiar with the child, and they have established short-term goals, long-term goals. So in addition to the factual basis being sufficient, I'd ask you to consider that the placement is appropriate, and we do have a letter from Wedgwood Christian Services indicating that admissions is approved, and I'd ask you to consider that placement. Thank you.
Thank you. Right. Well, for purposes of today's hearing, I do find that all interested parties were given notice and the opportunity to participate as best they were able to. I find that it's appropriate to authorize the petition as it relates to the child. In this case, there is probable cause established that her needs at this point are beyond what services can be provided to her in the community. That has been contributed, unfortunately, towards as a result of the absence of her two biological parents for a significant period of time, as well as the limitations of care in the time she was with her grandfather. So I am authorizing the petition and also authorizing the removal and placement in a qualified residential treatment program. The court has to abide by the Court Rule 3.965 in looking at the criteria for foster care placement, specifically first, whether or not custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being. This case, of course, is complicated further by a third-party custody arrangement. The mother has demonstrated a few gaps in parenting. She does not have custody of the child at this time. We have the testimony that during a visitation, there were some complications that she didn't handle well from a disciplinary perspective. We've also heard she's got limitations on housing and needs to undertake some services before she would be able to provide for the specialty and high levels of care that this child requires. The Maximus assessment outlines, and I'm going to visit that a little bit, some of the higher needs in this particular case. The court is also familiar with her limitations as a result of case number 23-021DL. Many of the behaviors that were noted while she was at the Morrisburg campus are mirrored in the behaviors that she was displaying at the home of her third-party custodian grandfather. Reflects many behavioral diagnoses that were found, again, and confirmed by care providers and the Maximus assessment, as well as limitations on her developmental levels that require heightened parenting skills. Our frustration management was noted on the summary as disabling, dangerous, immediate, or intensive action needed, for example. Secondary gains from anger certainly interfere with her functioning. And I also have to make note of the fact that the child was released from the care and custody of Morrisburg campus and was required to be picked up by grandfather August 21st. And he did not retrieve her from the campus until very recently, and that was really only as a result of the court's directive in the DL case requiring the Department of Health and Human Services to step forward. Because the child was at that point in time at Morrisburg campus and without any parent or custodian providing proper care or custody and without the authorization of the court. So I do find that all of those factors, as well as the absence of Mr. Buglatis at this time, his absence of relationship and her heightened needs, and we need more information about him as well. The fact that he's been absent from this child's life, in addition to mom's absence, as well as, and I want to say one more thing on that point too before I move back across to the next factor, which is that as part of today's pleadings, I received a modification of that custody order that allowed visitation at least by mom at 4 hours a week. There was a guardianship case that preceded the custody case, which would have required the third-party custodian to try to reach out and engage with the parent and allow that person notice to establish a guardianship. That didn't happen. Mr. Rublides has certainly been on notice for a long time. He could potentially be the father of this child. We're going to order DNA testing. It's been ordered and requested before, and I hope that he is able to step up, but at this time, I find that custody with him presents a substantial risk of harm to this child's life, physical health, or mental well-being. Specifically her mental well-being, she's opposed and she has heightened needs that would not be well served by placement. Not to mention that would be sending her out of state, which is beyond the control and supervision of the court at this time, which, given our lack of information about this gentleman, as well as the lack of relationship and preliminary risk indicators as testified to by Ms. Grant, certainly forms a substantial risk of harm. I've visited about the risk of harm associated with mom, as well as with the grandfather at this time. It's a very dangerous physical situation between him and the child at this point, given her significant behavioral needs and limitations, as well as the failure to retrieve her for a significant period of time from campus. The Maximus analysis provides further support for the fact that no provision of service or other arrangement except removal of this child is reasonably available to adequately safeguard the child from the risk that the court has described as it relates to third-party custodian and both parents previously. She has heightened needs that may only be met under qualified residential treatment programming at this time. For all those same reasons, the court finds continuing the child's residence in the home of the third-party custodian or as an alternative in either parent's care is contrary to her welfare. And I do find further that Ms. Grant testified to and the petition provides reasonable efforts were made to prevent or eliminate the need for removal. That also goes back to some of the things that we heard about the services within the community, including CMH, intensive home therapy programming, supervision by our probation department in the delinquency file, and the litany of other services through the school, including IEPs that were not able to assist any of our custodians, or potential custodians, or the child in eliminating the need for removal. The conditions present at the Wedgwood Christian Center are adequate to safeguard the child's health and welfare at this time. So as a result of that, I do find that it's contrary to the welfare of the child. For all those same reasons, the child to remain in the community and in the care of her third-party custodian, and she will be a ward of the court in foster care, in authorized for qualified residential treatment programming at this time. Thank you. Okay. So at this time, we are behind on the docket. So what I'd like to do, frankly, before we take your client's plea, Ms. Hennigan, is to take a 5 to 10 minute recess, and I'll rearrange things to try to get back on track time-wise.
I do have a question, Your Honor. I do have a scheduled seminar. I don't know necessarily that I need to be here for the plea. I have just explained to my client what's going on and what we have. Sure.
Any objection to Mr. McFarland being excused?
No.
No. You're good. Thank you. You are too.
In a shocking courtroom decision, the judge rules that the child cannot safely stay with her mother or grandfather because of serious behavioral issues and repeated dangerous incidents. Despite attempts with therapy, school support, and family placements, nothing worked. With no safe home available, the judge officially removes the child from the family and orders placement in a residential treatment facility so she can receive intensive mental health care.